Hi, my name is John Fox, and I'm the founder of Fox Law. I've been a practicing attorney handling personal injury claims for over 25 years. I have a tremendous amount of experience in this area. Today I'd like to talk to you about the Pennsylvania doctrine called statute of limitations. What does that mean? Well, it means, in most cases, that if you're in an accident, you have 2 years from the date of the accident to make a claim. Now, making a claim means filing a lawsuit by way of summons and or complaint within that 2-year period. If you do not do that, if you do not have an attorney file a complaint within 2 years, you will be forever barred from making a claim for personal injury. Under Pennsylvania law, contract claims have a different statute of limitations. It's 4 years. But because I'm talking about personal injury, it's 2 years. What about a wrongful death? How many years from a wrongful death can a claim be made? Same thing. 2 years from the date of death. And the claim must be made by the executor of the estate of the decedent. That means that an administrator or an executor has to be appointed after the death of someone who was killed as a result of an accident. Now, there is the doctrine mostly used in medical malpractice cases where someone might not be aware of the injury right away. In that case, there is the discovery rule where, what's reasonable in determining when malpractice actually occurred. And that can stretch the 2-year doctrine to a longer time period. I don't like to be in that situation when it occurs, but often people are not aware that malpractice occurred. Even through a reasonable investigation, they wouldn't be aware that it occurred. And therefore, the court looks to whether it's reasonable that they did not realize that malpractice occurred within the 2 years. And they'll extend it by the time frame that it would have become reasonable. So that's the exception, and that can be applied to other things, but it's mostly in medical malpractice.